You ever have one of those days where you walk into a room thinking it's just another job and walk out knowing your whole life just changed? That's what happened to me on a windy Tuesday morning in March, right in the middle of downtown Seattle. I'd been working as a corporate mediator for over a decade, settling multi-million-dollar disputes between companies who'd rather cut a deal than bleed each other dry in court. I'd seen all kinds: arrogant CEOs, petty feuds, the occasional screaming match. But that day was different. The case seemed routine. A licensing dispute worth $50 million between a fast-growing tech startup called Synergy Tech and an old-money manufacturing giant Sterling and Reed Industries. My job was to keep the room calm, get the facts straight, and guide them toward a solution. Simple in theory. I showed up at the Columbia Tower 43rd floor 30 minutes early like I always do. Set out my notes, my water, my legal pads. And as always, I set my phone screen off, microphone hot right there on the table. It looked like it was just resting there. But in truth, it was my insurance policy. Years back, I'd learned that when you're a black woman in rooms full of powerful men, words can get twisted. Moments can be misremembered and your reputation can evaporate if you can't prove what really happened. So I made a habit quietly, legally, to record every session. The first to arrive was Alex Chin, CEO of Synergy Tech, pacing like a man whose whole future was on the line. His lawyers seemed capable but tense. They knew the other side's reputation. And sure enough, at 9:15 sharp, the elevator opened and in swept Mark Harrison. If you've never met a man who thinks he owns the air you breathe, imagine a 6 feet 2 inches wall of tailored wool, a Harvard ring glinting under the lights, followed by 3 younger attorneys hanging on his every move. They walked in like they weren't here to negotiate. They were here to conquer. "Miss Williams," Mark said, flashing a smile that didn't reach his eyes, "I hear you've got quite a track record. Though honestly, this case looks cut and dry to me." I shook his hand, met his gaze. "Mr. Harrison, I've read the briefs. I think you'll find there's more to discuss than you expect." It was subtle, but I saw it, the flicker in his eyes. Men like Mark aren't used to being told that they might be wrong, least of all by someone who looks like me. From that moment, every suggestion I made was met with a challenge. His team cut me off mid-sentence, spoke over me, turned their chairs toward each other like I wasn't even there. I'd seen this dance before: death by 1,000 little cuts to your authority. 2 hours in, I called for a caucus, suggesting we start with Synergy Tech's team. Standard practice. But Mark leaned forward, voice cool and sharp. "We need to talk about your approach. My clients are paying a lot for this mediation and frankly, we're not seeing results." One of his associates, clearly emboldened, chimed in. "Feels like we're being managed instead of mediated." That word "managed" hung in the air. It's code. It means you're out of your place. I kept my tone steady. "Gentlemen, progress takes time. This is a complex matter." Another piped up. "Maybe we need someone with more experience in high-stakes disputes." Translation: "Sit down, little lady, and let the real lawyers work." I'd had enough. "This level of hostility toward the mediator is counterproductive and unprofessional," I said. Mark's smile vanished. "I think you're misreading the situation." Then it happened. Chairs scraped back. They stood one by one, moving in close. Before I knew it, my back was near the wall. 4 men forming a semicircle around me. One step to my left, another to my right, one behind me. Mark dead ahead. It was a classic intimidation play, and they were so used to it working they didn't even think twice. "Maybe you should consider if this is the hill you want to die on," Mark murmured. Then came the touch, a hand on my shoulder, another gripping my arm. Not shoving, not striking, but enough to make it crystal clear: "You're not leaving until we say so." The whole thing lasted maybe 30 seconds, long enough for my phone to capture every word, every movement, and every calculated angle of their bodies. When they finally stepped back, I walked calmly to the table, picked up my phone, and said, "This mediation is terminated. You'll be hearing from the Washington State Bar, the Seattle Bar Association, and my attorney. What you just did is assault, battery, false imprisonment, and professional misconduct. And unlike most stories, this one is recorded." Mark's face drained of color. "You recorded us?" "Washington's a one-party consent state," I said, smiling just enough to let him know the game had changed. I only needed my own. By 2 p.m. I was in the office of David Miller, civil rights litigator, an old friend. He called in his team, a discrimination specialist, an ethics lawyer, and a forensic tech wizard who handled my phone like it was a crown jewel. We didn't just have my video. Within hours of making a few quiet calls, we had statements from 11 other women, mediators, attorneys, even a court reporter, who'd faced the same treatment from Mark's crew.